It's the Law and Business Podcast, hosted by Anthony Verna. We tackle the hard issues where law and business intersect to help you understand your business's legal obligations better. Anthony's law practice is focused on trademark, copyright, other intellectual property, and advertising and promotion law. You can contact him at anthony@vernalaw.com and at 212-729-5651. And now, the Law and Business Podcast.
Welcome to the Law and Business Podcast. Once again, we have Jim Cushing. How you doing, Jim?
Greetings, everyone. Doing well, thanks. How are you?
I'm well, thank you. Jim, once again, why don't you tell everybody how to find you?
All right, Jim Cushing, but I think professionally on Google, you'd find me at James W. Cushing. My law firm is the Law Office of Fay Riva Cohen. That's F as in Frank, A-Y-E, R-I-V as in Victor A. Cohen. And my email address is jwc@fayrivaccohen.com, and 215-563-7776 is how you reach me. And I keep a blog called judicialsupport.wordpress.com, where I talk about law and a smattering of religion and music and some other things.
All right, so last time you were on, we were talking about a copyright infringement case, and it involved the album designer for I would say your favorite band, Yes.
That's correct. My favorite band is the progressive rock or prog rock band Yes, and but he's also the cover artist for other related bands like Asia and Gentle Giant, and he's done other things like architecture and stage designing as well. So
as we had discussed, he filed a lawsuit against James Cameron and other production companies involved in making Avatar, basically claiming that the design, the mise-en-scene was taken from a lot of his artwork. And ultimately, the federal court threw the case out on a motion to dismiss because the ability to make that claim that the mise-en-scène copied his artwork was really not able to be made.
Right. I don't think there's any doubt that either consciously or subconsciously James Cameron had Roger Dean's paintings in his mind when he made Avatar. They're very, very similar, but Anthony could probably expanded on it more last time we did this, but I don't think it meets the muster of a copyright infringement or anything like that. But they are very, very similar. And as a Yes fan and as a Roger Dean fan, I can tell you from reading all the websites, there was lots of great wailing and gnashing of teeth over this decision. But Roger Dean posted I'm a friend of, quote-unquote, on Facebook of Roger Dean, and he posted an update a couple of weeks back about the case and lamenting the fact that he lost, and he thinks that, James Cameron clearly used his work, and et cetera. And, but he had a certain number of days to file an appeal, so I decided to hold off until writing an update until I saw what happened in terms of the appeal. And today I checked the dockets and discovered that a couple of weeks back, Roger Dean and James Cameron decided to conclude the case. Roger Dean gave up his right to appeal the adverse decision, and about any case against Jim Cameron regarding Avatar and the copyrights. And in exchange for that, James Cameron agreed not to pursue Roger Dean for any attorney's fees or costs or anything like that. So the case is now over and completed, much to the chagrin of Roger Dean and Yes fans the worldwide, about this, what we believe to be I don't know. I was going to say grave injustice, but I guess according to copyright law, it is not, so it's fine.
Well, yeah, I mean, as we discussed last week, it's a matter of I was kind of surprised that they didn't really amend the pleadings to discuss how it was how each element may have been copied, and so therefore they kind of went with a very broad general copyright infringement claim, and the court said you can't do that because if there's a dragon, for example, dragons themselves aren't works that fall under copyright law, but your expression of a dragon would be. And they never took the pleading to that particular level, to be honest with you.
Yeah, I don't know. I never spoke to their attorneys.
Neither did I.
Right, I've met Roger Dean several times. As I said before, he doesn't know who I am, but I've met him several times at festivals and so on. And he was reluctant to talk about the case. And in fact, his update on his Facebook page last week said that he acknowledged that he's been sort of silent on this issue because, by the advice of his lawyer, is probably wise. So I don't really have any insight beyond what the complaint says, really.
So anyway, with the stipulation, he's not appealing. So this case is over and dead.
Yeah. Perhaps on the advice of the podcast we did last time. I don't know.
Well, if he's listening, hi there.
Yeah.
So, being a fan of the bands that you are, they've had multiple lineups over the years, and certainly what to call a particular band with a particular lineup can be a tricky. Can be a tricky situation. Certainly, I know the Beach Boys have had problems. At one point, there was a band called the Beach Boys and a band called the Beach Boys Experience touring. Go ahead. I'm going to give you the stage again, and just tell me a bit about some of these bands that you're fans of and their lineup changes and maybe some of their name issues.
Sure. Well, I was thinking more specifically about Yes and Asia because I feel they've had some very public legal issues, and I think one of the things that sort of tends towards an issue that like this, or with name usage in bands, and this probably sounds obvious, but it's bands that have a lot of personnel changes. Mm-hmm. One, and two, I think bands where you have one or two or three people who view themselves as the core of the band, right? Because like a band like Jethro Tull, probably 30 people have been in that band, but hardly anyone thinks they're more important than Ian Anderson, except for maybe Martin Barre, but even he doesn't when he left recently.
I mean, certainly fans of the Red Hot Chili Peppers can talk about the various lineup changes. I forget the name of the first guitarist and versus John Frusciante, who was in there for a short time, versus whoever is in there right now. I have no idea. Hillel was the name of the first guitarist who passed away. So and the various different stages, but most people, of course, see the Red Hot Chili Peppers as Anthony Kiedis and Flea, and anybody else seems a little interchangeable as well.
Right. So what happened with Yes, and actually with Asia too, I'll give you a little brief history of each, is that they each have had eras of the band where someone else besides who you might think is the prime mover in the band as the driving force. So with Yes, because they've been around for 45, actually more than that, 46 years, I guess, is that they've had two brush-ups with the law when it comes to the naming issue. As some people might not know, is that Yes is a 1960s band, had their heyday in the 70s as a progressive rock band, and they more or less broke up after 1980 when they had, I don't know if it was good or bad, but they had the Buggles, the band who the video Killed the Radio Star, sure. The first video on MTV. Right, the singer and the keyboardist for the Buggles joined Yes, which sounds crazy, but that's actually happened. And in place of John Anderson, a longtime singer and founder, and Rick Wakeman, they're probably their most famous keyboard player. The singer and as it turns out, the Buggles had the same manager and were a singer-keyboard player duo, and they were in the same studio, and they both had need of the other, so they joined, and it became Yes. And after that, Yes broke up, and was seemingly with nothing. Yes seemed to be gone because Steve Howe, who was in Yes, the guitar player, was off starting Asia, and John Anderson became a solo artist, and Rick Wakeman became divorced and became a solo artist. I mentioned that because he lost a lot of money in divorces in the 80s. And, and sort of Chris Squire and Alan White, would you believe, and it was recently in the news they might try to revive this sort of as an archival type thing, but Chris Squire and Alan White joined forces with Jimmy Page, and in theory, Robert Plant and maybe John Paul Jones to form a band called XYZ. At this point, only demos exist of Page, White, and Squire playing some stuff. And all that material has been since reused in the respective bands. But right. So Yes sort of ceased to exist, and by 1982, Squire and White recruited original keyboard player Tony Kaye from Yes, and this guy called Trevor Rabin from South Africa. They created a band called Cinema, which obviously sounded like Yes because it had three guys in Yes, and this new guy who's sort of an '80s power chord Journey type guitar player. And the record company said, you guys are good singers, but you really should get a lead singer. And they racked their brains, and Chris Squire said, I'll ring out my friend John Anderson. And John Anderson said, this is great music. I'd like to sing on it. And I think that the consensus was at that point, well, if you have Chris Squire, John Anderson, Tony Kaye, and Alan White, this is Yes. and Trevor Rabin being a consummate businessman, I don't think he, as an artist, I don't think he liked the idea, but Yes is going to sell better than some unknown band called Cinema.
Well, exactly.
And so it became Yes. And this is all the while Asia was hitting the top of the chart with Heat of the Moment and other sorts of things. And Steve Howe, over sitting in Asia, said, "Hey, wait a minute. I thought Yes was gone. I specifically remembered this band breaking up." And but it didn't. And so Steve Howe took issue with the fact that Yes is being used as a name and their back catalogs being used. I don't think he minded the royalties from the back catalog, but he minded they're using the music, and there was a legal dust-up with Steve Howe and with Yes, as it was in 1983. And by 1984, there was, and this is, I hope no one is judging me of the fact that I know all this nonsense. I just want to say that.
Now that you're saying it, right. You're like you've had this epiphany.
That's right. Yeah. This is not a commentary on my lawyering, please. So by 1984, everybody who's ever been in Yes, which at that point was like 12 guys, I guess, or 9 guys, or 10 or 12 guys, they all signed a licensing agreement in 1984 as to who was in, who was out, who could use what, and when. And Steve Howe, and in that sort of settlement, got use of the famous curly Yes logo, which is in use now. The one that's really famous. I don't know if anyone knows what that looks like. I'm sure Anthony could put a picture of it on this thing, but the famous logo. Steve Howe got that. And I'm pretty sure, although I'm not 100% positive, I'm pretty sure he got use of using Roger Dean as the artist, because Yes, without Steve Howe, has never used Roger Dean.
That is correct.
So he got that. So, and then the name went with the guys in the band, and there were certain rules regarding who could use the name when. So that was the first legal dust-up. And wouldn't you know it, 5 years later, 1989, or 88, maybe 4 years later, they had to use this document became the centerpiece of a legal issue that arose because John Anderson, when he rejoined with Cinema, had a 2-record deal. They made 90125 with Owner of a Lonely Heart, and then again Big Generator, the second one in '87. He became sort of disinterested in pop music, or not being in control of the band, because Trevor Rabin was now in control. Like I said in the beginning, you had this new guy as sort of the prime mover, Trevor Rabin. John Anderson was the '70s prime mover, and he was upset that he could no longer control the band, I guess, and he wanted to make different kinds of music, and that was unreceptive in the band and in the music and the record company. So, he and 3 other Yes compatriots, namely Bill Bruford, Rick Wakeman, Steve Howe, all decided to form a band. And when you have those four guys who made Fragile and Close to the Edge and some big Yes music, they're like, well, what are we going to call ourselves? And that became a problem, right? So they did not call each other. They didn't call themselves Yes. They called themselves, sort of coincidentally, like a law firm name. They called themselves Anderson, Bruford, Wakeman, Howe.
Or really more like Crosby, Stills, Nash and Young. Although that sounds like a law firm too, frankly.
Yeah, right. ABWH is what everyone started calling them, because they didn't want to say they weren't Yes, because they kind of were, but they also couldn't call themselves Yes. And Yes was existing, doing other things. They were, believe it or not, trying to recruit Roger Hodgson from Supertramp to replace John Anderson at that point. And so they sort of rankled Yes when ABWH started rearing its head in the publications, because the average public person, like Rolling Stone magazine or whatever, MTV, oh, this is the new Yes, and this is the new Yes album, and the Yes that existed with Chris Squire, Alan White, Trevor Rabin, Tony Kaye. They're like, no, they're not Yes. They're some weird imposters. We are the Yes. And then there was litigation that was raised in the Central District of California in 1988 or so, indicating, this release, that the general release they signed said, sort of barred ABWH from even mentioning Yes, from using their catalog, from being, because they thought it would generate confusion, which I guess, Anthony, is a normal standards, right? So, and so out of that, because John Anderson basically said, I never left Yes, I just had a 2-record deal. I never left. I just finished the deal, so I'm doing something else right now.
Sure.
And Yes had obviously a different opinion of that, and as to who could use the name and what. So, because I think the promoters were using the tour called it was called An Evening of Yes Music, was the name of the tour for ABWH. Which
it's creative.
And,
I'm going to give him.
Right,
I'm going
right.
to give him points
And,
for being creative there.
And what actually the even more creative, Anthony, is that the final name of the tour, when they also made a live album of this name too, An Evening of Yes Music Plus, because they're just not, they're playing their new material too. That's technically not Yes. And so that became obviously the sort of the locus for this confusion, and Roger Dean did their stage setting and their artwork too. And ultimately, it was resolved so that Yes could stay Yes and do whatever they're doing, which was not much of anything actually. And ABWH had to continue with using that as their name, although they could refer to their pedigree as Yes musicians and call the tour An Evening of Yes Music, but they could not call themselves Yes. I guess it was sort of an unsatisfactory resolution, because by 1990, would you believe, ABWH and Yes merged into one giant 8-man mess that went on tour in '91 for some fantastic shows.
So basically, everybody wound up at home anyway.
Anyway, yeah, that's right. But there was litigation that how to handle that, and since then the name and the logos and stuff have been negotiated. I think there was another one in '97, another agreement, because Rick Wakeman left in '96, and so it goes back and forth with that. Yes is always, now John Anderson's out and they're touring a totally different lineup, so. I don't know what the legalities of that is, but Asia has a very interesting situation where it's not like this sort of back and forth tug and pull with all the different members trying to do something all different. Asia started out as a progressive rock supergroup, probably much to the chagrin of a lot of the progressive rock bands, that their album turned out to be not quite as progressive as they were hoping. But Steve Howe, of course, of Yes, was in it. Jeff Downs of the Buggles and Yes was in it. Carl Palmer of Emerson, Lake and Palmer, ELP, was in it, and as a drummer, and John Wetton was bass and singer. He was from King Crimson, Roxy Music, Renaissance, Uriah Heep, UK, Family, bunch of stuff. And they made some albums with Roger Dean as the artist. And they made 3 albums. Steve Howe not on the third. He was in GTR with Steve Hackett at that point. And they were very, very successful albums. But John Wetton had as it turned out, a drinking problem, and they couldn't get along, etc.
A rock musician with a drinking problem.
Right. Well, he recovered. He's now in recovery, which is not good. But they made their first 3 albums in the early to mid '80s, and then they didn't do much of anything. But then by the early '90s, apparently there was some sort of groundswell, I guess, for Asian music. I don't know. Jeff Downs encountered this guy called John Payne. I don't know where he came from, but he's a bass player singer. And they said, "Do you want to play some music together as Asia?" And Jeff Downs, who was at that point the owner of the name, they said, "Sure. Well, let's do it." And they recruited other sets of musicians. And the original guy, John Wetton, was sort of unaffiliated at this point, except for, I think, a brief tour in the mid-'90s. But other than that, Carl Palmer and Steve Howe would make guest appearances on albums, like playing 1 or 2 songs. I think there was a tour in '92 for the Aqua album where Steve Howe played half the tour, like half the show, only playing his own material, and then he'd leave the stage, which is strange. So So the original guys are sort of in and out of sort of guests of their own band. Well, Jeff Downs and this new guy, John Payne, became Asia with other sort of rotating musicians. Everything came to a head in 2006, which was the 25th anniversary of the original Asia, where John Wetton was now in recovery, and there was and Steve Howe was dormant for by that point for a time, and Carl Palmer had nothing going on because ELP's been broken up, and so they figured, why don't we get together and form Asia again? And John Payne said, well, what have I been doing for 15 years? I've been in Asia for 15 years. And so much like somewhat similar to the Beach Boys you mentioned, Asia, the original Asia said, well, if there's anyone who has attachment to this name, it's the one that actually sold the albums and went on tour for people to see, which is the original Asia, because as much as John Payne worked hard, I don't think anyone cares about John Payne with Asia that much. They didn't sell 10 million albums like the original did. So the original album, so what happened is the original Asia, the deal was the original Asia got back together. They toured. They made they made 3 or 4 albums, 4 albums. Just a side note, they made one album called 30, XXX, on their 30th anniversary, and somehow Googling Asia, XXX made that a bad business decision. But that's an aside. and just as a note. And so they became Original Asia. Their name is just Asia, but their website's Original Asia. and their website lists as their discography anything from the original lineup, like the first 3 albums in the 80s and everything they did in the 00s. And then sort of like the Beach Boys, there's now Asia featuring John Payne, which is basically everything else done in that 15-year period between the original Asia eras. And so, John Payne, like I said earlier, you had Jeff Downes as the prime mover in the original Asia with the other guys, and John Payne became the prime mover after the other guys left. So you have 2 guys sort of 2 different eras saying, well, my era of this band is totally legitimate and therefore deserving of the name, and I think that's sort of where the problems arise. Where, like I said, other bands like Jethro Tull or King Crimson, you have guys that are important, but they know they're not the band. Robert Fripp is King Crimson, or Ian Anderson is Jethro Tull. But there's no competition for leadership. Where these bands, they have guys where they basically take over with the permission of other big guys, I guess, and they create their own sound, which is legitimate in its own right. So there you go. There's the brief history of Yes in Asia and the copyright stuff.
You ready to take a deep breath?
Yeah, please.
Okay, not a problem. Let me talk about a couple cases, then we'll get to why the cases look the way they do. Because hey, we're 2 lawyers, we're going to geek out talking about law. And that's I think kind of the point. There was a case called Kasbaum versus Steppenwolf Productions. And Kasbaum was a former member of Steppenwolf. And believe it or not, the Ninth Circuit said that Mr. Kasbaum, and I forget exactly what he played, was allowed to say that he was formerly of Steppenwolf, or an original member of Steppenwolf, or an original founding member of Steppenwolf, however you'd like to phrase it. And of course, as long as that particular phrase was not as prominent as the current band's name. So that basically you're telling the truth, right? This person is an original member of Steppenwolf, or, a founding member of Steppenwolf, or formerly of Steppenwolf. All of that's true. And this person is allowed to say that. And this person isn't barred from, in trademark law from doing that, not barred under contract law from doing that either. And there's another case called HEC Enterprises versus Deep Purple, and I'm not much of a Deep Purple fan. I don't really remember them, but apparently there was Deep Purple, and at some point, New Deep Purple, and
well, can I just say, Anthony, I just looked up Steppenwolf on Wikipedia.
Sure.
And I think the entire music industry has been a member of Steppenwolf.
Oh, probably.
There's like 40 guys.
Oh, probably. Absolutely.
And so saying the original members, that's saying something, because there's like 40 other guys to compete with. So that's something, I guess.
That's true. I'm not too sure that necessarily went into the court's consideration, but yeah. I mean, somebody's not going to go around saying 3rd generation member of Steppenwolf, no longer in the band.
No, right. I mean, this band was founded in '67, right? So you have,
I feel like
they have an entire. There's actually there's an entire Wikipedia page dedicated to just the former members of Steppenwolf.
Yes. It's like we're talking about a Christopher Guest movie now.
Yeah, just when people give me a hard time about the personnel changes, and yes, at least I can count them on 2 hands mostly.
and of course, to talk about the Beach Boys case, and that was called Brother Records versus Jardine, because it was Al Jardine, original member of the Beach Boys, who would use various names: Al Jardine of the Beach Boys and Family and Friends. Yes, that was actually used. The Beach Boys Family and Friends, the Beach Boys Family and Friends. And sometimes, of course, the Beach Boys, plain and simple, were just used. And, as we know, there have been many generations of the Beach Boys at this point, and Brian Wilson is, kind of, sort of playing once in a blue moon, as well. So who really are the Beach Boys? But in this particular instance, obviously, as you can imagine, the Beach Boys is a registered trademark. And here, using such phrases like Beach Boys Family and Friends, and even Al Jardine of the Beach Boys and Family and Friends, would confuse consumers. And actually, there's plenty of testimony in that particular case that people were confused, that not just concert goers, but promoters were confused as well. People didn't know that
There's actually a Beach Boys lineup Wikipedia page too.
Yes, of course, there should be.
Although their numbers are much smaller though. They don't include where did the John Stamos fit into all this?
I don't remember where John Stamos fit into that, to be honest with you. I think it was way after this particular case, because I think that case, because I forget exactly when Al Jardine left, but that case came before the John Stamos era of, I think, Kokomo. Probably. I could be wrong on that. But
according to Wiki, he joined in '84.
There you go. So Al Jardine was going around calling himself the Beach Boys, or using one of those mouthful of words. And of course, Mike Love was going around calling himself the Beach Boys. So you have these two original founding members both calling themselves the same name. But the fact of the matter still remained that Al Jardine was not a part of the group at the time, and there was still a collective calling themselves the Beach Boys, and he can't break out calling himself the Beach Boys or any of those particular phrases. And especially the fact that consumers were confused, but more than that, promoters were confused as well. So not just the music public, the music listening public, but also the music professional public that was out to book concerts and actually make money for these various entities was confused about who they were booking for. So that worked very, very strongly against Al Jardine, and of course he was not allowed to just call himself the Beach Boys at that time. So a couple thoughts here. And when we talked about planning this particular podcast, Jim and I talked about how do we deal with names, and on the federal IP side, I'll be talking trademark law in a second. But just as a mea culpa, I actually thought there were plenty of states that had laws about this, and you know what? I was totally wrong. I couldn't find any states that discussed band names. Specifically. So, and a lot of these cases that we're dealing with, that we're talking about, really talked about either one, trademark law, or two, contract law, or some combination thereof. And so, one, a band name needs to be a trademark, basically, is the real thinking here. And I should say a band name is a trademark. It should be federally registered. And there should be a formation agreement, or really what is a business agreement, and all the
partnership.
Exactly, a partnership agreement.
Because what it seems to be, if I can say it, Anthony, is that for some of these bands, I mean, I think maybe I'm stereotyping, but I feel like if people get into bands when they're young, in their late teens or early 20s, and they just want to play music. Right? They're not thinking about the implication of what would happen in 35 years of me being in this band. They're not really thinking about that, and I feel as though sometimes the guy who's the artistic inspiration of a band, like Brian Wilson and the Beach Boys, I mean, he's the guy who makes the Beach Boys for me. Maybe I'm just alone in that. I don't know about you, Anthony, but he's the guy who makes the sound for me. But he doesn't seem to be in your discussion as to the name at all.
Exactly.
Which is unfortunate, because without Brian Wilson, there would be no Beach Boys for people to fight about.
That's true, but in the 80s there was no Brian Wilson as well. He was dealing with his drug issues. He was right. Trying to get Dr. Landy out of the door. Talk about a
right. But so it seems like ultimately the people who fight about the name are the people who either are lucky enough to be in the place where they're the ones left, like Robert Fripp and Crimson or something, or they're the ones who think about with foresight, maybe I should get an agreement so I can use this name.
But yes, that's exactly what happens, and I can't really say that there's much wrong with what happens there. I mean, if a founding member goes to the family farm and decides to be a farmer instead of a musician, I mean, that person's no longer in the band, even if that was an original. If other people have to come in to fill that person's slot.
Now, is there any analysis in the amount of writing someone does, or the influence they have on an image? So, let's say, I'm trying to think of someone like John Lennon. Someone tried to use the Beatles' name, or Bono, and someone tried to use U2's name or something. I mean, those are like people who are either intrinsically important to the band as a writer or as an image person. So does that have any weight as to the claim to the name?
No,
or no?
It tends to be whoever is. It's really not about that particular issue. It's more or less about who is continuing that band's name. So if a founding member were to, drop out and go do some solo stuff, and that happens to be the face of the band, but like the three other people are still around and they want to record and they want to go grab a new lead singer, they're able to do that. And think about Van Halen, which has had 3 lead singer incarnations, and they're still Van Halen. Even though nobody's really going to think about Van Halen 3 all that much, and they're still Van Halen. So it's who's ever continuing. Even if it's that key image person who's probably done more songwriting than everybody else. So,
let's say in that example you gave, the bands of the first album or the first tour, or whatever, they become a name. People know who they are. There's original 4 or 5 or 6 members, whatever it is. That one guy leaves, and does he at that point have a right to say, well, this is no longer the band that I was in. You can't use the name.
I would say without an agreement, the answer to that's probably no.
So where is so for example, in 1969 or 70, when Yes was John Anderson, Chris Squire, Tony Kaye, Peter Banks, and Bill Bruford. Peter Banks was fired or left or whatever story version you want to use. Left 4 of the 5 still in the band. They continued to make music with Steve Howe. Is it the locus? How do you determine who owns the name? Is it by majority or where the locus of the music is, or what?
Just noting the fact that there is a radical difference in trademark law from '69 and today. I will say that in today's world, what you're looking at is probably majority, and if a band has 5 people and 3 are continuing to use that name, then that's probably going to be who wins out. Just because they've got 5, the other people have 2. And, it's going to be, without a contract, it's going to be very, very sticky for those particular reasons. I think what the cases tell us is certainly when one person is out of a band and still uses the band name and yet the quote-unquote original entity is still around, I mean, that's an obvious loss for the musician who's now on his own and forming a band. I mean, obviously you can go still play the music. I mean, that's a totally different area. But in talking about the band name itself, when you've got a cluster of people who, of course, are still, who have that history and might still be signed under the record deal, and that's kind of, you're looking at these things as to what's the continuation, and if it's some kind of odd number split, probably the majority is going to get it.
So even if an odd number split, it would still be. Again, I sort of going back to the question I asked you earlier. Is it still is influence in the band still a factor? So taking it back to Yes, for example, let's say John Anderson, Chris Squire left Yes in 1969. The 2 guys who wrote all the music at that point in time, but the other 3 guys were a majority, but they didn't write really anything. What would do you think the court would do? That would be, the majority. The guys who didn't write anything have majority, but the guys who wrote all the music and are the image are the 2.
I think the court might go with whatever the record label would go with, to be honest with you there. So if the record label is recognizing the other guys as the band, then I think a court might follow in that particular direction. Because if 2 guys leave the band, and even if their face and an image and songwriting, so they put in the work, if they're the ones who say we're no longer part of the band, all right, well then everybody else must be a part of the band, and so I think a court might go in that particular direction. Is there a distinction between that and, I'm sorry to put you on the spot it's okay.
there. I mean, cross-examining.
No worries. No worries, counselor.
Is there a distinction between someone leaving the band and like with Yes in 1980, where people thought the band was dissolved, and then someone picked up the torch again and said, no, we're going to bring it back.
Well, in looking at this from a typical trademark law standpoint, because I think that's what we would have to do in absence of a contract, or and in this particular case, let's just make that assumption. Trademarks are abandoned after 3 years, and I know this is going to sound a lot of just really weird to a lot of people, but if on one hand, I think we can separate a typical business and a band. And if a business no longer uses a trademark, another business or person can come around and pick up that trademark after 3 years and just use it for the same goods and services because the other original business is no longer using it. It's been abandoned. For bands, I mean, all of that applies as well. I would say here the difference is that if somebody were to have come around in the late 2000s and call themselves, Toad the Wet Sprocket, you'd sit there and say, well, no, you're not Glenn Phillips, and the guys aren't here, and yeah, the website's kind of dead, but you're not Toad the Wet Sprocket. And I think a lot of music fans would be wired to do that. And even if under trademark law, that would have been fully acceptable.
Now, there's a record company who still makes their... I mean, I'm sure Atlantic Records or Virgin or whoever it is. I don't know who's still buying Toad the Wet Sprocket CDs. I'm sure there is somebody. Maybe,
me?
probably you. Apparently you.
Me? I bought the last one.
Right. So does, let's say that a band goes 10 years without making something and they're dormant for want of a better term, they're gone. But the record company still makes their CDs for the two people who buy them a year. Does that keep it alive?
I think so, and that's actually what I was going to say. I mean, you can look at the example of REM right now, who is officially dormant and broken up. But when you go look at their website is still up, giving you updates about everybody. They released a couple of rarities collections. They released their MTV Unplugged complete series. So they're still putting out stuff as REM, and I think you'll see that probably be the wave of the future, so that the name can at least be encapsulated by the original members. And I have no doubt that while REM is no longer going to make new music, I certainly highly doubt that the four original members are not owners of the corporation, for lack of a better phrase.
Well, because I have to tie this into prog rock, Bill Rieflin, REM drummer, is now in King Crimson.
Bill Berry.
There you go. What's that?
Bill Berry, REM drummer.
Yeah, there's a guy called Bill Rieflin, apparently, who's a member of REM as a drummer.
I don't Bill Rieflin?
Yeah,
How do you spell that?
It is R-I... Well, you know what? The King Crimson website says he was, but it's RIEFLIN.
Okay, so he probably was... he probably came around...
Yeah, his website and wiki says he, quote, worked regularly with REM.
Yeah, so there you go.
To me, he's a sideman.
Yeah, there you go. There you go.
He's King Crimson's third drummer. And when I say third, I don't mean in a row, I mean all at once.
But yeah, so I think you're going to be seeing more of this, and I think for a lot of bands, getting back to your original thought is gee, when you're 18, 19, all you want to do is pick up a guitar, pick up a bass, pick up drums, and get out your anger and make some music, and you're not thinking of it as a business. And one of my earlier episodes where I spoke with Jay Thorne, who's a horror writer, he said, that he's an artist, but he also has to think of himself as an entrepreneur. And for a lot of bands, you need to think about yourself as a business, and that means having a partnership agreement, understanding what a band name is and how to properly protect it. And if you start, when you start making money, how to properly protect it, and understanding copyright law, and making sure that your copyrights are registered, that your royalties are coming in. Whatever is required in your business, you have to make sure that it's done correctly. And a lot of people just don't quite see that when they're working in the arts.
Right. I guess with bands, ultimately, I mean, they might not have a contract with one another in the bands, but I would suspect if you're going to sign with any sort of record company, there has to be something, some pen has to be put to paper that says, this is the entity that's entering into this contract for it to sell records or whatever.
Yes, and I'll tell you a classic example, since we're jumping around generations here, is Crosby, Stills, and Nash, and I think. I'm trying to remember when they were going for another record, and was it Stephen Stills who had no, it was David Crosby. So it wound up being a Stills and Nash album, and the record company said, no, we wanted a Crosby, Stills and Nash album, and this doesn't fulfill your contract. And so you have that happening at times throughout history. And that's probably going to be an issue, and yes, so the record companies do keep track of who is in, also because there are performer royalties as well. That's another reason that record companies keep track. And a performance royalty is a new kind of right, and anything before 72. Those people are not getting a performance royalty on top of any other sales royalties or copyright royalties, etc. So,
let's say, you mean when you say performance royalty, you're not talking about
You're
not talking about putting on a concert.
If any recorded music after 72, the people who perform get a royalty, as well as the writers for any sales. So that if an artist is singing somebody else's song, and that song sells, whether it's on a compilation, in other words, a CD, or it's sold by itself as an MP3 or as a single, or gets radio airplay, there are going to be rights passed out to the songwriter, but as well as to the musicians who have played on that track.
Okay.
So there's going to be a separate royalty there. So record companies need to keep track of who's in a band and who's playing on what song anyway.
And I imagine there's the writing credits are important for that too.
Well, yes, absolutely. And in copyright law, it's required that when a royalty is paid, it's paid to all copyright owners. And at this point, and in today's world, the songwriters, are going to be the copyright owners.
Right. Well, the performance royalty is for all, right? Or just the songwriting royalty?
Both.
Okay.
Both. Yeah.
So if Lennon McCartney wrote a song, but all four of them played it, so that's two different royalties,
yes,
depending on who participated.
Yes.
Okay.
Yes. Of course, like I said, all of any performance of all four Beatles is before 72. So, if you go by the White Album, Sir Paul's not getting any money from performance royalties.
Wait, because I thought he didn't perform in the last two.
But no, what I'm saying is that was before 72.
Oh, right. Okay,
yes.
Well, that's when the laws changed.
Yes.
Okay.
Yes.
Well, this is probably a podcast for another day, but there's a couple of people in yes who say they've never gotten their royalties for something, or maybe they came very late, or they're still fighting for them, or whatever from years gone by.
I wouldn't be surprised with that. I mean, you will find in newspapers and music heavy cities, or in music publications, you'll find a list of royalties of that are supposed to go to people that quote unquote cannot be found. And I will certainly tell you that Paul Schaefer's name will be on that list. And I don't know about you, sure. I think he's pretty easy to find. So,
well, a couple of funny stories, if I could.
Sure.
One, I'm not going to mention. I represented this woman in a divorce, and her husband, probably now ex-husband, I didn't finish the divorce with her. He was a performer in a somewhat famous band that plays Christmas music. And he...
I have a couple guesses already in my head, but anyway.
That's right. And so it was sort of like a Seinfeld episode, because she was telling me about these royalties that she was due to receive as part of the marital estate, which in theory is true, I guess, depending on the situation. And so she gave me this list of like all these royalties, and like she said thousands of dollars that she's due, and she needs to get her share of this, et cetera. And I was sort of sharing in her the justice of it all, and this is why it's a Seinfeld episode, if anyone watches Seinfeld, is that until I realized these royalties are Japanese. So they're all in yen. So the royalties are always like $750. It's like, I don't know. But so she didn't realize that the yen were like vastly like smaller than $1, for example.
That's all right. I just heard an interview with Rich Eisen from the NFL Network where he said that he just got home and from a flight and opened his mail, and there was a royalty check from doing 2 episodes of CSI Miami, and it was something like $2.45 in residuals.
That's right.
So
hopefully his arm won't cramp up writing out the checks like Jerry Seinfeld did. No, but there was the first episode of episode is the wrong word, but the first featured case on Court TV was Patrick Moraz, keyboard player for Yes Refugee, but ultimately the Moody Blues, when he was asked to leave the band or kicked out. I'm not sure what the circumstances of his departure were. He was apparently, much to his chagrin, and I guess didn't know, he was not an official member of the band. So when he was just touring and playing, he was toured and played on the studios and wrote the music, but I guess he was an official member, and so he didn't get the royalties he thought he was deserved. So he took him to court, and it was on Court TV. Interestingly enough, I guess. But I saw my wife doesn't go to see progressive rock concerts with me anymore. She did that while we were dating. Well, yeah, she did that when we were dating, I guess, because that's what you do. And then, she went to a bunch of, I'll give her credit, she saw Yes with me, she saw Porcupine Tree, so she was a good sport. She saw the Dixie Dregs, and just as an aside, the last thing she ever saw was this group called the Musical Box, which is a group that's officially licensed by Genesis and Peter Gabriel to put on shows, note for note, and literally note for note, just like Genesis would.
How did they sound? Like, how did the vocals sound as compared to
Peter? Oh, it's unbelievable. It's their claim to fame is that they if you line up pictures of their show next to a Genesis show, it's exactly the same. They play all the notes exactly the same. All their body motions. They finally look at the footage. They try to duplicate a Genesis show as best as you humanly can. It's amazing.
Wow, I had no idea.
And I remember going to this Musical Box show with my wife Tiffany, and they were replicating one of the shows from the Selling England by the Pound, and Peter Gabriel, the guy playing Peter Gabriel, was wearing the bat wings and the goofy face paint with the real incandescent eyes, and they're glow in the dark and all the weird backgrounds and the costuming. And she looks at me and she goes, "This is it. This is the last one."
But
right. So anyway,
I find that interesting that there's a band that's basically licensed, in order to sound and look exactly like, another band.
Yeah, because that era of Genesis is so unique with the performance and the staging and the costuming and the music that I guess people didn't want it to die out because Genesis became totally revolutionized in the 80s. And Peter Gabriel occasionally will recognize the fact he did this. He usually doesn't talk about it, but sometimes he does. And he gave them literally the stage props to do it, and a lot of the vintage stuff. And Genesis, the rest of Genesis, will sometimes even sit in with the band, and it's pretty neat. But in one of the tours shows she saw with me before the end was we saw Rick Wakeman at the Electric Factory in Philadelphia. I'm from Philadelphia. I practiced in Philadelphia in 2005, I think. And it was Rick Wakeman's solo show, and this is relevant to royalties. And if you don't know, he was a very, very popular and prominent session musician. So he's played on countless albums that most people have heard, but they don't know it's Rick Wakeman of Yes. And a couple of first 2 David Bowie albums, Black Sabbath, Lou Reed, lots of stuff. And so this one was in particular Cat Stevens, "Morning Is Broken," which I think most people have heard.
So.
Right, Anglican Christian hymn. And Cat Stevens wanted to play it, and he hired Rick Wakeman as a session guy to play the piano. And as most Christian hymns are, that's like a minute and a half long, right? So although singles are short, they're not that short. And Cat Stevens said, "Well, Rick, can you Why don't you come up with an introduction? You played an introduction. Okay, why don't you play... okay, well, good. Why don't you do the same thing at the end? Okay, we'll play the same thing at the end. And Rick Wakeman's telling the story in the middle of his songs, and when I saw him. Okay, do a little middle thing. Okay, and that gets the song out to like 3 minutes, and they added another bit. That's great. And they recorded it, and it became a big hit. And later on, Rick Wakeman was supposed to get his check for his royalties. And he never got it. Cat Stevens called Rick Wakeman and said, hey, could you give me the music for what you played? Because we're going to go on tour, and this is a big song, and we want to make sure you play it. And Rick said, well, sure, yeah, I'll give you the music. Just, give me my check. The check never came. And so when we saw Rick Wakeman perform, he pushed the piano away so you couldn't see his fingers, because to this day he's never been paid for those royalties. And to this day, Cat Stevens has no idea really what he played exactly, and so it's never been actually replicated as on the album, because Rick Wakeman refuses to disclose that until he gets his. At this point, it's probably like $5. Who knows?
But I'm kind of surprised at that, because it's not hard for a lot of musicians to just figure out what somebody else is playing. I'm kind of surprised.
Well, I'm sure they figured it out, but he's just
right.
He just does it on principle.
Sure. It reminds me very much of a case I had when I first broke away from my old firm. And
there was no dispute over the name when that happened, right?
Right, no, exactly. But when I took over a case, and it had to do with a documentary that was made, and I represented a cameraman, which seems a little bit odd to a lot of people, because a cameraman's work doesn't necessarily belong to him. It belongs to the production company or the company that's hired him to actually just point the camera. But there was no agreement, so that's issue number one. And issue number two was more so that the interviewer who came to do the interview for this documentary came with about 3 questions, which is, nice for maybe a half hour's worth of shooting. But if you're actually putting together a documentary, you need to have 4 or 5 hour sessions with people that you're speaking to. And really, these clips in a documentary of somebody speaking for 30 seconds is culled out of 4, 5, 6 hours worth of footage.
Sure.
And in this particular case, our argument was that my client put in a lot of authorship, and that what was done was very much a work of authorship by needing to pad 30 minutes worth of conversation into 3 or 4 hours. And that he was able to do it on his feet. He was able to keep the subject talking, and he was able to get them enough footage that they were then able to put into the documentary and make a better documentary out of. So it's very much a similar argument. Like, here's somebody who's made, it's a little easier when somebody's a musician, has written music, but it's the same issue. It's like, oh, yeah, all right, you recorded it, but now I want the check for my authorship, and that's effectively what that is there under copyright law.
Yeah, because he participated creatively in the creation of this documentary as much as the other players in the thing.
Absolutely,
I would think.
No, absolutely.
Right. So I guess the moral of our story today is get everything in writing. Doesn't matter which role you play. Make sure you have a partnership contract.
Boy, it sounds like such a lawyer, doesn't it?
Yeah, that's right.
I know, and it's not like we're here to suck the fun out of music. It's something that I've certainly done. I've done partnership agreements. I've done trademark searches for musicians, and it's something that a lot of bands don't quite think of. But ultimately, down the road, when you plan your business, which is effectively what a band is, it's a business, and you plan for down the road, when you get to trouble points, it's easier to deal with them.
Well, think of it this way: the writing if you're an 18 or 19-year-old guy entering in the band, and you're writing a partnership contract, you're basically saying that you're going to be around in 20 years to make that important, which is a good thing for your career, I guess.
It's
because otherwise,
to me, it's a sign of.
I do have a question for you, Anthony. Before we sign off, I do have a question. My father-in-law, Matt Stauffer, he's in a band.
Okay.
He's a musician. He was never able to get the big record deal that he wanted, but he still tours and locally in pubs and bars and has bands and so on. And he's in a band right now called Geezer, and he's a funny guy. And so there are a bunch of guys in their 50s and 60s playing music of their era. And so, obviously, they made an album out of someone's house on a PC, right? There's no record company.
Sure.
And by album, I just mean a series of covers. I don't think they have a whole lot of... They only have one or two original songs that I know of. And so there's no record company, there's no record deal, there's no contracts, there's none of that. There's a website. But, can someone else use that name?
Well,
it's just a garage band, more or less, of old guys.
Going back to traditional trademark principles, because that's effectively what we're looking at here. The first question we have is there interstate commerce? One, is there commerce to begin with? And two, is there interstate commerce? So let's break that out into two questions. And then the next question that we have is this the most senior user of the mark? Because especially in the goods and services. So if there was another band out there called Geezer, using obviously same goods and services, whether it's recording music or performing music, certainly they're related. So you have to look at all of those questions and get those questions answered before you get to your yes or no. Of course, it's not necessarily a flip some bits and you get a definitive answer.
Well, as any answer the lawyer gives you, it depends.
Of course.
Right.
Right.
So I guess for a garage band like Geezer, I mean, they're not, they're a Philadelphia area, bar. They perform in bars and such. So I mean, if some group came up in like Toledo, Ohio, or Boise, Idaho, with the name Geezer, which I'm sure there's other people using the name, that would necessarily, I guess, cause a conflict because it's not really a band that goes out of the 5-county Philadelphia area.
Sure, and like I said, you're going to probably, with a lot of some businesses, you'll see that particular conflict happen. And I'm actually dealing with this for a client right now. Like, who do we have the right to send a cease and desist letter to? Is the cat even just out of the bag? And those are particular questions that you always have to answer. So here it's going to be right. Are there bands that are senior to this band? And even that isn't necessarily definitive, because if one band's only been around a year, that's going to be different than another band that might have been around for 3 years, and it depends on how long this particular band is around as well. So all of those are, when you start going down the checklist of things that you have to answer, the it depends typical lawyer, thing that we joke about really does come into play.
Thanks for answering.
I do my best. All righty, sir. I will let you return to work. Jim, thank you so much for joining us.
Thanks. Until next time.
Of course, sir. I'll talk to you soon.
All right. Thanks.
You're welcome.
Bye.